in the Alec Murdaugh case. A lot of people thought he wasn't doing a great job, but he was, and he closed that case with a guilty verdict that I think stunned the nation. So that was a key moment he was talking about in the trial that led the jurors to conclude that Alec Murdaugh had killed his wife and his son, Paul. On a new episode of the Untold Story podcast up now, Murdaugh's attorneys are now appealing that decision. As Murdaugh defense attorney Dick Harpootlian tweets this: "No amount of vitriol or misguided attacks will stop us from pursuing due process for Alec to the fullest extent of the law." So let's bring in Mark Eiglarsh, criminal defense attorney and a former prosecutor. Great to have you with us today, Mark. It was interesting to speak to both of them, the AG and Creighton Waters, who prosecuted this case. But of course, as we all expected, Alec Murdaugh will appeal this case. And here is a bit of Jim Griffin, his attorney, talking about some of the reasons that might underlie that appeal. Watch this.
Cars would be pulling up, and there's some tire tracks that were not being protected, and that they could have evidentiary value. Rutland talked about seeing hair in Maggie's hands, you'll recall. You didn't hear anything about the hair in Maggie's hands. We know they failed to take fingerprints from the feed room. Why did they never take DNA samples off of Maggie's clothes?
Mark, good to have you here. Appeal as expected. Does he have grounds for it, do you think?
There are grounds, but I don't think they're going to carry the day and get him a new trial. His best argument is not what just flowed from the defense lawyer's mouth, but the fact that they let evidence of his lies and his fraud to come into a murder trial. Generally, that stuff cannot come into evidence. But the judge, in considering the prosecutor's request, balanced their need to prove motive versus the prejudicial effect. And there was a prejudicial effect. He looked like a liar. He looked like a scumbag before he ever took that witness stand. And that generally shouldn't happen in a murder case. But the prosecutor said, if you don't let the financial stuff in, we can't prove motive. So the judge let it in. And that then becomes a valid issue on appeal. Do I think that that's going to lead to a reversal of the case? No.
So let's take a look at this other piece by Jim Griffin that would also be part of this appeal plea. Watch.
Asking questions of Alec about why he did not come forward and tell law enforcement where he was at the time of the kennel video. And that was after he was arrested. And there's U.S. Supreme Court cases are clear that post-arrest silence cannot be used against you. And that is a classic violation of the Fifth Amendment.
Is it, Mark?
Yeah, that's another good argument. Sure, no defendant should ever have to come forward. I think either it's not going to be deemed error because he took the witness stand and opened the door, or what appellate courts can do is say, we think that that shouldn't have happened, but we're going to call it harmless error, meaning there's so much other evidence of his guilt that that's just harmless. It's okay.
Interesting. All right, Mark, thank you very much. We will stay on it. A lot of tentacles to this case that are still worth watching. Good to see you today. Have a good weekend.
My pleasure. Take care.
So comedian Russell Brand talks to Fox